Hello, welcome back. I'm Roger Royce, host of the 10,000 Startups podcast, Legal Strategies for Startup Success, where each week we bring to you a discussion with a thought leader in the space and an expert on the topic in an area of startup company law that would be of interest to you, the founder. And this week, we're going to talk about bringing companies into the US from the United Kingdom. And since our speaker is Andrew Pannell, he's a partner in the investment management practice group in Haynes Boone's London office. Since our speaker is in the UK, we're going to focus on the UK side of this. So this is of interest to any startup, non-US startup company that wants to come into the US, but of particular interest to United Kingdom startups that want to come into the US in some manner, maybe even a flip in here completely or just establish a presence in Silicon Valley, which we often see. Now, as I said, Andrew is a partner in our Haynes Boone office in London, and his practice focuses on advising venture capital, private equity, and corporate clients on venture and growth capital transactions. So emerging growth and venture capital on the other side of the pond. So welcome, Andrew. Maybe you could tell us a little bit more about yourself and what you do.
Thanks, Roger. Thanks for inviting me on the podcast. So my name's Andrew Pannell. I'm based in the London office at Haynes Boone. As Roger mentioned, my practice focus is predominantly in the investment management segment, and with a particular focus on the venture capital side of the industry. It's a mix of working with venture managers, family officers, in terms of their investments into the startups, and also acting for startup strokes emerging companies as they look to scale up their businesses, both in the UK and Europe, and also as and when they are considering expanding abroad, again, whether in Europe or across into North America as well. And as Roger mentioned, I think there's a trend certainly for aspiring and successful startups who are looking keenly at the US market, given the size of the market cap, whether that's in the form of a organic selling to that market or actually setting something up from a legal presence perspective.
Okay, and again, for those of you just joining us, because we're now live streaming on Facebook, sorry, I forgot to mention that, Andrew. Roger Royce, 10,000 Startups podcast. We're talking with Andrew Pannell. He is a partner in the London office of Haynes Boone. He does emerging growth and venture capital. And we're going to talk about bringing UK companies into the United States. So, Andrew, let's start with kind of the base case. We have a company that has been very successful overseas in Europe or in the United Kingdom. And they've got a product, they've got revenues, they've got traction. They might even have investors. And now they say, boy, I'll tell you, that California and that US market sure does look tasty. I wonder if maybe we can just expand into that market. So here on this side, I'd probably tell them, well, we're going to form a US corporation, probably in Delaware, and you'll launch through that Delaware company. Any particular issues on the UK side when they want to come into the US by doing that?
Yes, so I think probably the first question before getting too far ahead and getting too excited is really what's the strategy for the business in terms of that expansion, and what are they actually looking to achieve? So there's probably three ways in which a UK company may be entering that market. The first way might be simply that they have customers that they want to serve in the US market. That would be the sort of basic, simplest way. The second might be they might set up some kind of actual legal entity, a subsidiary. Or the third way may be where they're looking for certain reasons to actually flip the UK headquarters and actually move it over to the US. So those are probably the three sort of base cases, and depending on which approach you're taking or the evolution of the business, the issues are going to be a little different in each case. I think on the first one, that's obviously the lightest touch, and that may be a little earlier in the piece, and just because you have an interesting business which is looking at North America, it doesn't necessarily mean you have to set up a presence, and you may not wish to. So there may be a few issues around that, but you may actually take the decision that you don't even want to set up. But there may be issues such as looking at your terms of sale, and are they fit for purpose? The ones that you have in the UK, in the US market, and some of the differences that may occur in the UK versus the US. And then on the second case, in the case of the subsidiary.
Can I stop you for a second on that? Because that is really significant. The fact that the laws are just different. And for example, I've run into this problem. Maybe you could talk a little bit about it. When you hire distributors, here in the US, in California, we've got a special statute that sort of protects distributors from any unfair terminations. But I understand in Europe, it's way different. It's much more protections, contractual protections by regulation and law. Is that the kind of thing we might have to consider if, for a UK company hiring a US distributor?
Yes, I think probably one of the obvious areas there is that whilst people might think both the UK and the US are quite similar given their common law jurisdictions, which is true. I think both from a legal perspective, but also culturally, they're quite different as well. So if, for example, you have a UK company looking to impose their terms and conditions in that US market context, is that the right way of doing it? For example, if you had an English law government contract with a customer and then something goes wrong, then there would be a potential need to look to enforce that contract. You may be able to successfully sue for the case in the UK courts, but how would you be able to actually then ultimately enforce that against the US counterpart? Given that there's no treaty from a court enforcement perspective. Now, it may be possible, but it may be a case of having to, in effect, restart that litigation in the worst case, because the courts in the US may have some discretion over that situation. One way of trying to deal with that issue, obviously, you could consider, would it be appropriate in that situation actually to go with US law, or at least certainly take counsel in the US to understand that? Or the other thing to consider is putting something like an arbitration provision into the contract, because there is the New York Convention, which the UK and the US are party to. So I think that's one good example. I think the other area which is obvious probably from a UK versus US perspective, there tends to be a little bit more detail perhaps on the common law side around limits on liability in terms of how far liability can be, exposure you can receive in the UK. Whereas I think in the US, my understanding is that unless you put it down in the contract around exclusions, the potential for things like consequential damages, which could result in not just immediate breach and liability flowing from that, that could lead to much more significant and unexpected liability and exposure, unless you have very tightly drafted exclusion provisions in that.
Yeah, absolutely. I've had a couple clients get completely wiped out because they didn't have a limitation of liability or a cap on consequential damages. And it's like, hey, we would have made billions of dollars if not for your infringement.
Yeah.
So that's significant, just the difference in laws. But let me kind of cut to what everybody usually does, because that's a whole nother discussion, international law and how they interact. The typical transaction that I see here in Silicon Valley is we have a non-US company, let's say a UK-based company, and they want to establish a presence here. Not only a presence, but they want to move here and put their headquarters here and their parent company here so they can go get investment from local VCs. And what we typically call the flip transaction. So we start with a UK-based company. We form a Delaware company. We drop the UK company into the Delaware company in exchange for shares. So poof, now we've got all our UK shareholders now own shares in a Delaware company that owns 100% of the UK company. That's the typical transaction. And I want to run through a handful of UK issues on that I've run into. There's a whole bunch of US stuff we'll do another podcast on. But on the UK side, the one thing that jumps out at me when I do that is, first of all, if there are UK investors, wow, investment terms in Europe look way different than they do here. I thought US VCs were tough until I saw a UK shareholders agreement. So number one, what kind of protections would you expect a UK investor to expect? Not only in the UK company, but even when it flips into the US.
Yeah, so I mean, actually, two things I just mentioned initially. The first one, and we can maybe talk about this in a bit more detail in a moment, but when you're looking to do that flip, from at least from a UK tax perspective, in order to make sure that that flip is done from a non-tax leakage perspective, it's absolutely critical when affecting the share exchange that the terms of the existing investment in the UK vehicle are pretty much 100% mirrored from a class rights perspective when flipping up to the US entity. So effectively, you're looking to simply mirror and interpose that holding entity from a substantive perspective. And if you don't, the potential for inadvertently triggering a disposal for UK tax purposes, CGT, and or stamp duty leakage could occur. So first of all, there are certain, and it's quite strict from experience of doing that in the past. So that's one thing just to watch out for, and we can talk about
that for a minute. Could you explain what that is, CDT?
Sorry, CGT, capital gains tax. Sorry. Yeah.
Oh.
Yeah. So it's critical to do that sort of mirroring structure. So if you want to do things from a tax efficient perspective, then it will be necessary to largely mirror those preferred rights if there are any. To answer your immediate question on what type of investor terms or protections that investors would typically expect in a UK European context, I guess you're right. Maybe the market is a little more conservative, and particularly for early stage investors at the pre-seed or seed stage. As soon as you have an institutional check coming in, typically you would have your classic downside protections, such as liquidation preference. Normally a 1x non-participating liquidation preference in the case of a liquidity event. You may have anti-dilution protection as well in the case of down round.
Is it the same kind of like we have usually it's broad-based weighted average here, which is really kind of nothing.
Yes, no, absolutely, and people can get a little excited, but yes, generally speaking, it would be a broad-based weighted average ratchet, as opposed to anything like a full ratchet or anything crazy like that. So those are probably two of the more economic protections. The other protections which may cause some angst, perhaps maybe in the US, is around governance matters. So typically the lead investor or the investor majority group would have consent rights, certain consent rights, normally split into two buckets. One across things which might actually impact on the class shares, the actual economics, like future equity issuances, exits, that type of thing. And then the other aspect, a little bit more operational, but around not increasing significant salary raises or capital expenditure, that nature of things. I mean, those are probably the absolute sort of fundamentals that one would expect from a UK European perspective. Probably one area which is maybe a little different, and maybe we're a little harsher in the UK Europe on the founders, would be founder vesting tends to be relatively robust, I would say, in the UK European, particularly for the earlier stage startups, whereas perhaps in the UK, in the US, perhaps that founder vesting, whilst it exists, it may be a little sort of sitting more on the company founder side.
Yeah, do you typically have buy-sell provisions in your UK shareholder agreements, meaning that say somebody is fully vested, but they leave, does the company have a right to buy back their shares? Because we would not typically have that in the US.
Yeah, so in the US, I understand that once you've earned it, you've earned it. Generally speaking, no. So in the UK, certainly, and I would say this is across Europe as well. In certain circumstances, there is the ability to claw back shares if you are what they would call a bad leaver, and often it's the devil in the detail about what is meant by a bad leaver. And if someone's been fraudulent or committed gross misconduct, it's one thing, but a bad leaver can even sometimes be talked about as someone who's a voluntary resigner. So in that bad leaver scenario, there is the potential to lose the entirety, so vested and unvested equity, as opposed to just the unvested, which would normally be where the good leaver provisions come in.
Yeah, I've run into those bad leaver provisions before. It's a little surprising sometimes, but so we got to watch.
Yeah, and it's actually it's interesting because I'd say that probably like the US, many term sheets you could probably guess 95% of the provisions, or even 99%. But if there's one area which almost always gets negotiated, it's around vesting. So when people talk about what's market, it often gets negotiated one way or t'other, depending on the nature of the investor, I would say.
Okay. Anything else as a corporate matter that tends to be problematic, where we get our U.S. parties choking on it when we do these deals?
In the context of the flip, I think probably the main thing is what I mentioned around when we're looking at the tax aspects and making sure that there's that mirroring element. And so if you've got, and so much of this will depend on what the capital structure looks like. If you have a fairly plain vanilla ordinary class capital structure, or even just say one class of preferred, it's not so complicated, but you may well have convertible loan notes in there. You may have a safe, even a UK equivalent of a safe.
UK has safes also.
Well, we've sort of imported the concept and UKFI'd the safe, if that's a word, in certain cases. So it's sort of a variation on a convertible in many senses. So that's probably where it gets more complicated. And I would say that the mirroring element also is something to keep in mind, because depending on the size of the cap table, if you've got a relatively contained cap table, that's fine. But where you've got a business that's been operating for a little while and it has a significant number of shareholders, which many startups do, just the sheer practicality of being able to implement these provisions is difficult, because generally speaking, if you're looking to affect one of these share exchanges, you're going to need to get everyone to sign up to these provisions. So logistically, that can be a real challenge, I would say, in my experience.
Everybody, wow. So we can't just force these on people. They really have to sign up to it.
Yeah, so I mean, one improvement, actually, the British Venture Capital Association, the BBC equivalent of the MVCA in the UK, some of the latest provisions, we've now drafted in some provisions around holding company reorganizations. So I think that hasn't always been in the documents historically, but I think that will help things, and perhaps including a power of attorney to go along with those provisions in the event that a minor shareholder is either being difficult or alternatively just isn't available and not involved. So I think that will help, practically speaking, to implement these things. Yeah.
Well, that's good.
Yeah. I mean, the other area which I don't know you were maybe going to come on to was around employees and incentive plans.
That was my next question. That's where it's another trap, I think, in these deals. I run into real problems with that, because it seems like the UK concept of equity comp is a little different than the US concept.
Yeah, so I think again, it'll slightly depend on the nature of the transaction, but in that flip context, well, taking a step back, first of all, in the context of early stage businesses, we generally have in the UK an ESOP which is what we call EMI driven. So it's basically UK tax driven scheme, and is intended for UK employees to give them some fairly significant tax breaks around their, in effect, the main one being that's receiving some options and not having to pay any immediate tax on them up front. And then when it comes to actually exercising options, then being able to be taxed on only a capital gain as opposed to on income tax, which is obviously generally a much more significant tax bill. So there's a significant benefits at the early stage of being able to receive those options. And they're also, it's a little more flexible than the US as well, in that in theory, a company can grant options with an exercise price at purely nominal value, whether the company is got any value in it or not. You know, in certain cases, it's an early stage company. It may not have any value, or you can argue that it's got very little value anyway. But even if it did have value, you could, in theory, grant those options at 0.001, for example.
Which you can't do in the US, by the way. Like you said, we've got Section 409A, which constrains us on that. But go ahead.
Yeah. So I think in the context of if you were setting up a subsidiary entity in the US, obviously those UK EMI options would continue to apply as before, and that shouldn't have an impact from that UK perspective. But what we would normally do is we would run a parallel scheme of what we call unapproved options, and so non-UK employees, that could be UK consultants who don't qualify for this EMI status, or it could be US or anyone else who's employed elsewhere, could potentially be granted options in that UK parent, if that made sense from a US tax perspective, which it may or may not. But you could do that sitting alongside, and then it would be an analysis from a US perspective at what market value, looking at 409A valuations, etc., as part of that. Now, I understand that there may be an argument, for example, taking restricted stock instead, but that's more of a US discussion to be had. But there is at least flexibility to build that alongside that EMI UK scheme. If we're talking in flip territory, normally our option arrangements will have in them provisions which allow for replacement options.
Okay.
So sorry, can you still hear me? So
yep. Yes, we can.
Sorry. Yeah. So they will have provision for replacement options. So there is the ability to roll over those options, if that makes sense, into that non-UK or holdco parent. And be granted options in the equivalent parent company as well for those UK employees. So again, provided you structure it correctly, that there is a manner in which you can preserve that EMI status. So it is doable, but it's important to look at that carefully.
Okay, great. Yeah, because that is one of the big issues here. Well, I think we've kind of covered the big topics here. Is there anything else that should be top of mind for anybody, especially a UK company coming into the US that wants to do this? I mean, we've covered a lot. Anything we missed?
I think just the one other thing, again, back on the sort of tax, I guess, and incentives is, from in a UK context at least, there are a number of tax incentives that startups potentially receive from early stage investors, what they call EIS and SCIS relief, and the idea being to encourage high net worths to put money in on a completely at risk basis. In return for that, UK taxpayers who are high net worth are able to receive significant tax breaks on their own income, either 30 or 50%, depending on the nature of the investment or size, and also CGT relief, free of tax as well at the end. Now, again, in the context of that flip arrangement, that needs to be considered very carefully, to make sure, or do your best not to cause issues with that S/EIS treatment. And whereas in the case of the share for share exchange relief I mentioned, normally you would go and get a ruling from the UK tax authority, HMRC, but you don't have to. But if you're looking at an SEIS or EIS qualifying company, it's actually mandatory to get HMRC clearance ahead of doing the flip. So that's again very important from an investor perspective preservation.
Yeah, absolutely. Tax is always a driver in a lot of these deals.
Yeah.
So we want to pay attention to that and preserve good tax benefits. Well, okay, Andrew, I really want to thank you for giving us that overview. It's a little more complicated on the non-US side, as usual, than on the US side, but this is good to know. I guess the last question is just want to make sure people know how to find you if they're considering this transaction. So how do we find you?
Well, I think if you Google Andrew Pannell at Haynes Boone, you'll find me on the website at Haynes Boone for sure. And I'm obviously contactable through email or other such communications. So yeah, if anyone has any questions from this podcast, very happy to answer anything. And we'll look forward to working together, Roger, on these type of transactions in the future for sure.
Okay, thank you very much. This is Roger Royce with the 10,000 Startups podcast. We'll see you next time.